What if the home you lived in for 30 years isn't legally yours? And that's what exactly happened when people staying in Richmond, British Columbia received the mail with the letter saying that their property title might be unsecure. But this situation is not just being discussed in British Columbia. It's already being discussed in Ontario, where historic land claims are resurfacing that might affect the homeowners staying there. So in this video, we will discuss why these land claims are resurfacing and how court is reviewing the historic indigenous titles and what it means for homeowners. So by the end of this video, we'll know exactly what's happening behind these headlines. Land claims are the request made by indigenous people. They are saying that land was originally ours. Indigenous people, they lived on this land even before Canada existed. In many areas, no treaties were ever signed, or the treaties were unclear, broken, or unfair. And over the time, the government took land, built cities, railways, and farms, allowed people to settle on the land without proper consent. And because of this, indigenous people are saying that our land rights were never settled properly. And this is why these land claims are resurfacing now. Let's see a real example of this issue. A recent court case happened in British Columbia between the Cowichan tribes and the city of Richmond. The land involved in this case is very large. It's about 750 hectares of land in Richmond. This land includes city land, port lands, farms, golf courses, and commercial properties. The area highlighted in the green is the claim area, and this is not empty land. People are living there, working there, and owning property there. This ruling is now affecting homeowners. The city of Richmond issued letters to the homeowners. The letter said that the recent court ruling could negatively affect the property title, and some banks have started to refuse to renew the mortgages. And also, because the homes are inside the land claims by First Nations, property firms are also said that new loans are on hold after the Cowichan ruling. So, the same legal reasoning used in BC is now being talked in Ontario. The Haldimand Tract issue is a long-running land dispute between the Six Nations of the Grand River and the governments of Canada and Ontario. The land dispute involves a large strip of land along the Grand River in the southern Ontario. The land was granted to the Six Nations in 1784. It was given as a reward for supporting the British during the American Revolution. The lawsuit, it began in 1995, and the trial is now scheduled to start on October 2026, more than 30 years after the case was launched. And because of this long delay, fear and confusion have grown. On social media, some people are saying that if you live in this area, your house may no longer be yours. They claim it does not matter how long have you owned the home or how much you have paid for it. These claims are spreading uncertainty and panic even before the trial begins. But community leaders and experts, they are consistently saying that the goal of the claim is not eviction but compensation. There is no plan in removing the homeowners from their houses. So, after hearing all this, a natural question comes into your mind that can you still buy and sell a property in this area? I would say the short answer is yes. Properties are being sold and bought in this area, and thousands of transactions are already being happened. Property titles, they remain valid until court overrules them. But perceptions matter a lot in real estate. Even though everything is legal, but fear and uncertainty can change behavior. In Ontario, real estate deals uses standard purchase agreements. This agreement includes, let me scroll down here, these agreements, they usually include title search date, pre-printed clauses that requires good and marketable title. Lenders look very carefully at this. They want clarity, possible indemnities, exceptions listed in title insurance, lawyer opinions or letters that must stand up to legal scrutiny. For banks, clean and defendable title is not an optional, it's essential. So here is the real concern for the lenders. If court decisions, questions are set aside crown patent, then it's a collateral risk for the banks. So what happens in practice? There will be more scrutiny, like more legal scrutiny, case by case underwriting, not automatic approval, close monitoring of affected areas, and often higher costs, delays, and more conditions for borrowers. Also, in Canada, property rights are not protected by Charter of Rights and Freedom. Instead, property ownership comes from provincial laws like the Land Title Act, the common law. This means property rights are created and managed by governments, not guaranteed by constitutions. This gives parliament and provinces more room to redefine how crown title works, recognize historic indigenous possession, and adjust land title frameworks without violating the charter. And that is why recent modern claims are taken so seriously. So the next question comes, that should realtor disclose these land claim issues? In Ontario, there is no legal law for realtor to disclose this issue, and simply a land being in a claimed area does not automatically require a disclosure. But realtors do have professional duties. Two rules matter. If buyers ask directly realtors this question, then they should answer truthfully. And realtors do owe fiduciary duties towards their client. Likewise, banks have collateral risk, realtors have liability risk. And if this information changes buyers' behavior, then this could later be argued as material latent issue. In British Columbia, many brokerages have adopted a written disclosure template for land claim related issues. These templates document what was disclosed, align realtors' practices with lenders' caution, and reduce the risk for everyone involved. So, if this land claim litigations continues to rise in Ontario, then it's reasonably to expect that Ontario brokerages might adopt these similar best practices. So, before wrapping up, these land claim cases are not limited to just one province or one court cases. There are several land claim cases are being active across Canada, and these cases are being closely watched, and they are mostly targeting governments and not homeowners. So let's look at some of the cases. So first, it's Kamloops to Sequempik. Apologies, I'm not able to pronounce the last name correctly. So this case was in Kamloops area. It was filed in 2015. It covers about 543 square kilometers. It was originally aimed at restricting mineral mining, and the nation has repeatedly stated that they do not intend to remove existing residents. Second is in Gatineau, Quebec. It's Kitigan ZB Anishinabeg. I think it was filed in October 2024. It often compares to Cowichan style cases because it seeks recognition of Aboriginal title in developed areas. And the third is like half of New Brunswick. In 2021, 6 New Brunswick First Nations, collectively forming the Wolastoqey Nations, filed a claim seeking Aboriginal title over more than 50% of New Brunswick. Also, there are some recent federal settlements that have happened. First is Cumberland House Cree Nation. So in February 2025, the federal government agreed to pay 570 million settlement for specific land claim dating to 1876. This includes adding 27,000 acres to reserve. Second is Flying Dust First Nations in Saskatchewan, where government reached a settlement of over 55 million plus the return and designation of 200 acres to reserve, correcting historical land losses due to railway exploitation. And the third is in where Canada settles claims with 15 Saskatchewan First Nations, where 1.72 billion was given to 15 First Nations over unfulfilled treaty promises regarding farming equipment and support. So, Canada is re-examining how land ownership laws must align with Indigenous rights. For some land parcels, they are not for sale in usual sense because Aboriginal title must be recognized and reconciled and not ignored. So, this raises a next bigger question. Should fee simple ownership always come first, or is the coexistence between the private ownership and the indigenous rights is the best path forward? Tell me in the comments below. And if you have enjoyed this video, please hit the like, share and subscribe button for more such insightful videos for the future. Until then, see you in the next video. Bye.